That is the only portion that refers to Mr. Makalani's statement, my lord. And as we undertook that we'll try and neaten up the submissions pertaining to Mr. Makalani, correct all the typing errors. We have since done that. It's nothing new, my lord. We just a separate document, and I've given a copy to my to my colleagues. It's
Okay.
in essence it's the same document. The only difference, my lord, is there was a lot of unhappiness from my colleagues that we are introducing something new. It's nothing new, my lord. We're saying that the evidence of Makalani is on record, that in considering the evidence in this matter, the court should also consider the evidence of Makalani, and we're saying what the legal basis is for the consideration of the evidence, namely that by introducing the document, they agree to the hearsay evidence. Alternatively, in terms of the interest of justice test, that the evidence be allowed. That's all that we say, my lord. Nothing new. It's already on record.
Iphelele lapho ke inkulumo ke ethimba labashushisi futhi basho khona lapho ukuthi ilokho kuphela bebafisa ukuthi bakujobelele malana nenkulumo yabo bathi futhi lobu akusibo ufakazi obusha ke lapho ke ngoba ke lokho sele kukhona ngaphansi kohlelo owajashikelelwa la ngaphambi kwinkusinkantolo bacela ke futhi ukuthi inkusinkantolo ke isamukeleke le statement leso mhlawumbe lodaba lolu lwenkulumo ade khona lapho umnomzana ke uMakeleni.
Death certificate has been handed up as exhibit ZZZ in brackets 4.
Bathi futhi nencwadi ke embikayo ukuthi na ke sele washona bayibiza ukuthi death certificate ngesingisi bathi na sele ikhona ngaphambi kwinkusinkantolo ke naye futhi bayiqaphile lapho mhlawumbe emakhela lapho ukuthi imibuki unobokola ngaphansi kumibukiso ka ZZZ4.
That is.
That's it, my lord. There was one portion that my learned friend wanted to bring to the attention of the court regarding the proceedings at Boksburg Magistrate Court, namely Exhibit EE, pertaining to what accused number 4 would have said. We are mindful of the what the court mentioned yesterday, that was before the litis constantatio, but the fact of the matter is that it is on record. We just want to mention, to put that on record.
If I checked it, I told you it deals with the same issue.
Yes.
There's an AD case. Actually, there are two. They arose as a result of a magistrate in the regional court in Mthatha. He wanted to appoint two what are the guys who assist these guys?
Assessors.
Assessors. He wanted to appoint two assessors. But what he did is he appointed these two assessors after the charges were put against the accused. There were about 3 or 4 accused in that case. But in any case, the evidence was not yet laid. So Falam was the judge there, and a gentleman called, I've got it, I would say, we must give you that thing. Falam and his co-judge, the 2 judges who were to attend to the review on this matter. And they held that before these guys were sworn, properly sworn, there was no evidence laid. So even if you can say the magistrate delayed in swearing them in, but evidence was not laid until these guys were sworn in. But they thought it had to be contemporaneously done. But these two judges, intelligence dictates that they're correct because if the evidence is led because the judges, the two assessors were sworn in, it would make their sitting ineligible because they've got to hear everything that starts as from the plea downwards. But Bennett goes on and says, if there's no litis constatatio, the case has not commenced. He's right.
Yes.
I can give you the citation, as I say.
Yes, that we accept, my lord. But
Yeah, fine.
there was another complaint by my colleagues that their attention was never drawn to those proceedings.
Now it was drawn.
Yes, we have, my colleague has got those relevant portions
Yeah,
where
you can read them so that,
where they specifically asked for those proceedings.
yeah, fine.
Yes. And we just wanted to place that,
Okay, fine,
that
no
on
problem.
record.
I recall because Mr. Ngomezulu was still there. And there was an argument whether Mr. Mjiako was appointed, blah, blah, blah. I remember that argument.
Yes, yes.
But read that record.
Yes, we just want to...
Because the point is, it is on record.
yes.
But whether it is evidence, that's
Yes,
what is
that's-
another matter.
Yes, there's
Okay.
something else, yes.
Yeah.
I'm sorry, my lord. Still, I don't understand because the court has made a ruling. The state is still pursuing on the very same issue.
Yeah, but he wants
I don't
to-
understand.
I hear you. But he wants to show that what he was saying is what happened on the 27th in court.
What is the relevance of that?
Ask him, because he says you are the guys who are saying that never happened.
But it can be done later. It's not the end of the road.
No, let him do it so that we're through with it.
Yeah, I'll just quickly, whilst we're still looking for that, this exhibit EE, the proceedings of the 27th.
Yeah.
Advocate Mnisi says we had actually requested those records from the state. I think it was almost last year, September, October. We gave them a formal letter saying that, can you at least finish us with the transcribed record of the proceedings of that day? Because we are well aware that the copy of the charge sheet that my colleague is referring to, which is Exhibit EE, that is a handwritten copy. And that copy, God forbid, magistrates do not write all that what is happening and being said in court. They are trained to write that which they think is necessary for that particular day, but a transcribed record reflects whatever that happened on that day verbatim. And we then, on that basis, my lord, handed those transcripts to them. And during the proceedings of 30 January 2024, line 10 to 15, Advocate Mnisi says, despite the fact that there are those records that have been made available, the disc and the record of the transcript, quote, but we have read those, and Advocate Mnisi says, I have read them, they have been handed to us now. So this is just a confirmation, my lord, that we did bring that to the attention of our colleagues. But there's just that one portion which of Exhibit EE, which we want to put in record, and this is the proceedings of 27 October 20.
I'm going to object, my lords, to this so very unknown procedure. The issue, my lord, in this application, or the issues in this application, are specifically defined. There's been an application by accused number 4 that on the basis of the fact that the state has not been able to establish a prima facie case against him on all the counts, he requested the court that he should therefore be discharged at the close of the state's case. The state's response, the manner in which they've responded, that is the issue that needs to be determined at this point in time. Now the state stands up, and it is struggling. It's very struggling. It stands up and say, no, but there's a Makaleni issue. There's the record of the transcript, my lord. What do those submissions have to do with the application that is so circumscribed, that is so specific? And I've indicated on Tuesday, my lord, that the state, if it feels like there is something that they have missed in the presentation of their evidence, which I would refer to as struggling, they would still have the opportunity. There is nothing wrong in terms of the procedure for them to stand up and say, my lord, we acknowledge the fact that we had already closed our case. But there is information that we feel, in our view, that would be the state saying that we can use at the end of the state, at the end of the close of the case, to make an argument that will supplement our application for a conviction. Then the court will have to make a decision on whether or not it grants them that leverage or that allowance or that indulgence. But not now, my lord. Because if I were to stand up and start to address the issues that the state is now raising, this procedure will be very precarious. It will be unheard of in any civilized legal system, particularly in a system that is codified. And ours in South Africa is codified in terms of this Criminal Procedure Act number 51 of 1977. Such procedure is not allowed, my lord, particularly when there's an application in terms of section 174. This section must be dealt with and be finalized. Then the state, as I've said, if they feel there is something that they need to add into their struggling evidence, then they can stand up and say, no, we also want to add this another struggling point in our struggling evidence through an application. The state does not even apply now. It simply says, we also want to add this, we also want to add this into the record. What is the purpose of this sitting, my lord? Is it to introduce new evidence or to make a determination on whether or not accused number 4 has been able to bring to the court an argument which in the mind of the court says that it should be discharged, or the state which in the mind of the court says accused has not been able to discharge the honors in terms of section 174. Those are the issues at this point in time, my lord. Otherwise, the procedure that is being followed here, Fiasco does not even begin to explain it, my lord. It's unheard of.
Yeah, fine. I've heard you. You see, the problem with you and your colleague arguing, you discuss things in my absence, and then you want me to solve them. You see, he says, you approached him. I wasn't there. No. And you complained about A, B, C, D, E, F, G. No. And now he says he's rectifying what you complained about. Am I correct, sir?
That's actually, it happened in court on Monday, as he says. That's what they said.
Now I'm being blamed for not knowing the procedure.
Yes.
No, my lord. I am not saying the court does not does not know the procedure. But what I'm saying is the procedure that is being followed here is unheard of. That cannot be equated to mean that the court does not know the procedure, my lord.
Are we
Now,
through with
the issue is, my lord, there are issues which have been raised here. And the procedure at which we are now, which is an application in terms of section 174, does not allow parties who have not made an application in terms of that section to respond to the issues which the court needs to determine. Accused number 1 and accused number 3, accused number 5 and accused number 2 are not party to these applications. And yet there is evidence which in their mind seems to be evidence that is being introduced through the back door, my lord. Would we then be afforded the opportunity to respond? And the court said on Monday, yes, you will then respond. But state proceeds, still continues to introduce new evidence
Okay, so are we... what are
through
we
the
doing?
back door, my lord. Well, I don't know if this procedure, if the court really affirms this procedure, I'm in the hands of the
No,
court.
don't talk,
But
about, don't talk about the procedure because I'm telling you what you do in my absence.
No, but my lord, there was no agreement. There is no
I don't
agreement
know,
that we've...
but you spoke to him.
About what, my lord? We spoke to him
Okay,
about
okay,
what?
fine. That's it. I
I
hope-
never speak to the state, my lord, because I know the way in which they operate. Everything that I do, I make it a point that it is done on record. I know the way in which they operate.
As we pointed out, that is, we're responding to their complaint on Monday that they were not made aware of the proceedings. But, my lord, we've made submissions.
Yeah, fine.
We have summarized the evidence. All that we are saying is stating the obvious, that in considering the conspectus of the evidence, these are the issues that are already on record that must be factored into the equation. Nothing new. We're putting on record what ought to be considered. I don't understand the objection by my
No,
learned
it's
friend.
okay.
Nothing, no new application. We're just saying the court, as we have done, we have summarized the evidence. These are aspects that we could have mentioned in the summary of our evidence. We're just saying, in addition to the summary that we've given, these are also the aspects that must be factored into that summary. Nothing new, my lord.
Okay, is that the end of the argument?
Yes, so
So what do we do?
yes. I think Advocate Ngumalo wanted to respond to the state's submissions, and that's where we are in terms of the process. But there was that one aspect that we wanted to put in record that appears on Exhibit EE, which would form part of, which forms part of our submission as far as accused number 4 is concerned. And as I say, this is not something new; it's already on record. The proceedings of 27 October 2020, page 5. The last 2 lines, accused number 4, Your Worship, I do not see the necessity in acquiring legal assistance because we do not have money. Since we've been brought before court, the people who are supposed to be appearing before court are not before court because they have money. That's all that we wanted to put in the court.
Okay, fine. Yes, yes. Is that the end of this application now?
Yes, those are our submissions, my lord.
Yes, Mr. Normal. Are you through too?
My lord, I'm not in a position to respond because in respect of the statement of Makaleni, the 7 requirements in terms of the Act have not been met. I've never heard the state discussing the issue of the nature of the proceedings, the nature of the evidence, the purpose for which the evidence is tendered, and the property value of the evidence of that statement. In fact, my lord, in my address,
You're not quoting the SC, the Constitutional Court case of Darcy. You're not quoting that case, sir.
no,
Yes, the one that we quoted, my lord, it's Kappa.
Because it is the,
Kappa.
yeah, it is the Constitutional Court speaking there. It's not the,
The Act speaks.
Yeah,
The Constitutional Court refers to an Act. So
Yeah.
when an application is made, the seven
it's a judgment
requirements.
of the Constitutional Court. What
Yes.
more do you want me to say?
Yes, I know
And
that.
he's reading that judgment.
Yes,
And that judgment says there are 7 categories which must be satisfied.
yes, yes.
So what is the problem?
Has the state satisfied those requirements?
I don't know if I'm saying that judgment, as I understand it, that's what it says.
I understand, my dad. Further to that, in my application, I never referred to the statement of Makalene. So how does it find its way through this court in this
Yeah,
application?
fine, you can argue that if you want.
Because, my daughter, I've referred this court to the case of Mgedezi to say that for the 5 requirements, they must be met for my client to say he formed common purpose with the others. But now the state is referring to the Makaleni statement, of which I never referred to Makaleni, as to how Makaleni and accused number 4 is related in respect of this application that I've
Yeah, you
dealt
can
with.
argue that. I must reject that argument.
That is my argument,
Yeah,
my
fine.
daughter, that I'll respectfully ask the court to reject that evidence.
Yeah.
It finds no application in the application that I've made before this court on the 25th of August. That was
Okay.
on Monday. Thank you, my daughter. Thank you.
Right, so when do we reconvene?
So, my Lord, may I perhaps find clarification? On Tuesday, when the issue of Makaleni reared its ugly head, Advocate Mnisi stood up and inquired from the court whether, because of that Makaleni issue, which was not canvassed in Advocate Ngumalo's application, and it does touch on particularly Mr. Ntanzi. And further, my Lord, regarding the manner in which the response by the state seeks to have the extracurricular statements of accused number 2 apply to all accused persons that are before court, which is anti the Mhlongo case. So on that basis, Mr. Advocate Mnisi asked whether we will be afforded an opportunity to reply, and the court confirmed that we could reply. Hence, in the morning, I was asking, is that procedure? Because those are fundamental issues in this application, my Lord. It has escaped the circumscription for the application and the reply. Now we are in Stswana. We are touched by blood. That was not meant for us.
You know what? If you guys apply the law, and you know the law, there won't be problems. If he knows the law and he applies it, there are no problems. If he does the same, he applies the law and does it, and he argues, and you say, I must write a judgment, I'll write a judgment because I know the law.
Yeah, because we found ourselves perplexed.
So
whether-
if you want to supplement your heads, you can do it, no problem. If you think it's necessary.
My Lord, I stand as an officer of the court because I did not per se make an application. But if I see issues that I feel as an officer of the court that things are not going well, my Lord, I should stand up and ventilate and assist.
I can tell you what is your problem.
Yes. What is my problem, my Lord?
If you read that charge sheet,
Yes.
it says the 5 gentlemen there are charged in terms of section, common purpose, and then it's section 51 what?
It's 51.
Just read 51.1, because that is the problem, I can tell you now. Jesus.
51 is more of minimum sentence.
Yeah, the conspiracy part. They don't charge with conspiracy.
What we do mention in the indictment that
To say?
they are charged in terms of common purpose and or conspiracy, but
In the indictment.
yes, in the indictment,
I think that is the problem here.
yes.
As I understand the law, if you are charged in terms of a common purpose and a conspiracy, It applies to, according to the state, not me. It applies to everybody who's charged.
My Lord, 51 deals with sentencing.
No, he says it's not. He says he mentions it as a
Yes.
conspiracy.
Yes.
Okay,
Yes.
that's how I understand it.
Because, my Lord, for me, the concern is this Makaleni issue, the procedure that I know is that before the close of the state's case, the state, if it wishes and intends to lead or to have the court admit hearsay evidence, it stands up and makes an application to the court to say, my Lord, we've let hearsay evidence, for example, of Makaleni, and we are making an application for that hearsay evidence to be admitted. And both the parties, the state argues the admission and we argue against the admission. And the court makes a ruling. Now we are stuck here where these things enter via the back door.
I only make a ruling when I deliver the judgment.
Yes.
Not before.
Yes,
Okay. I listen. Before then, I listen.
yes,
If he misquotes the law, I just listen.
okay. Yeah, because that was my concern, that the law was
So
quoted.
if you and Mr. Ngumalo say there is no law like that in South Africa, fine.
Yes, because,
I can tell you there is a law like that. State S versus Roll.
a law like
Wait.
what, my Lord?
There's another one also where this judge, and he's a very experienced judge, it's, I think it's Falam. Falam was handling a case in Joburg. The state and the defense argued, and they closed their case, both of them. And then Falam made an order that there should be an inspection in loco held, because there is an aspect which he wants to examine at the scene of the alleged murder. And it did that.
My Lord,
No, I'm telling you that
yes,
this is
but
something
before
new.
I sit down, my Lord, let me just also refer to the law, my Lord. The infamous Ndlovu SCA judgment case, the one that was
Yeah,
overturned.
Goldstein.
Yes.
You used to sit in this court with me.
Yes, where
Goldstein.
Judge Cameron, my Lord, and I just want to read this paragraph, and then perhaps we can engage with his
He
lordship.
wrote
further.
the appeal.
Yes,
Goldstein wrote the judgment in Joburg.
yes,
And then Cameron, when he went to the SCA,
yes,
he handled the appeal.
yes. But that one, my Lord, and I'm quoting at 338
Yeah.
A2C of the judgment, it says, third, an accused cannot be ambushed by the late or unheralded admission of hearsay evidence. The trial court must be asked clearly and timelessly to consider and rule on its admissibility. This cannot be done for the first time at the end of the trial, nor in argument, still less in the court's judgment, nor on appeal. The prosecution, before closing its case, must clearly signal its intention to...
Is really going to be
Okay, let's put on Tuesday then. 10 o'clock Tuesday. Okay.